Hello everyone. Today in this video we are going to discuss about other important provisions of annual general meetings under Companies Act 2013. This is part second of our earlier video about the same topic. Today we'll be discussing all the provisions under the Companies Act that is related to AGMs of a company. So in a earlier video, we have discussed the basic provision like a company has to hold a annual general meeting every year. What shall be the time gap? What shall be the last date till when the AGM has to be held? Or whether the AGM can be extended or not, and if yes, then till what time it could be extended. So all those basic points regarding AGM we have already discussed in our part 1 of my video. So this is part 2, wherein it discusses about other important provision that has been covered under various sections of the Companies Act 2013. So let's move forward and discuss the same. So section 129 deals with the financial statements of the company. So under section 129 subsection 2 of the act, it provides that at every annual general meeting, the board of director has to lay down the financial statements of that financial year. So the very basic point that at every AGM, the board of director has to lay down the financial statement for that particular financial year of the company. So this is governed under section 129 subsection 2 of the act. Now under the same section 129 but subsection 3, it also provides that if a company is having one or more subsidiaries, okay, if a company is having one or more subsidiaries, then it has to prepare one more statement apart from financial statement that has been given under 129 subsection 2. Apart from that statement, the company having one or more subsidiary has to prepare a consolidated financial statements and of all subsidiaries in same format and also present before the AGM of the company with the prescribed statement under 129 subsection 2. So it says that if a company is having one or more subsidiary, then that company has to prepare its financial statement that has been provided under 129 1, and along with it, it has to lay down that in its AGM. Apart from that financial statement, it has to prepare a consolidated financial statement, and that also the board of directors have to lay down it in the AGM. This is provided under section 129 subsection 3 of the Companies Act 2013. So now I hope this point is clear. It is very simple, only different sections has been referred here. Okay, so let's move forward. Now it says that what all are the businesses that have to be transacted under AGM at any AGM. So if you read section 102 subsection 2, then it provides that at any AGM there are certain fixed businesses that would be considered as ordinary businesses, which can be transacted only at annual general meeting of the company. And apart from that businesses, all other businesses would be called as special business. So first of all, let's see what are the ordinary businesses. So as you can see that section 102 subsection 2 provides that consideration of financial statements and reports of board of directors and auditors would be the first ordinary businesses. Then declaration of dividend of the company, appointment of director in place of retiring one. So in place of retiring director, the appointment of director, it will also be considered as ordinary business, which can be transacted only at the AGM of any company. And the fourth point is appointment and fixation of remuneration of auditor. So these are the four basic ordinary businesses which can only be transacted at AGM. And apart from these four businesses, all other businesses would be called as a special business. Okay. Now you can see here the third point, it says appointment of director in place of retiring one. So do not confuse it with the general appointment of directors. It is only those appointment that is in place of the retiring director. Okay, so that would be considered as ordinary. So these are the ordinary businesses which is governed under section 102 subsection 2. Moving forward, special businesses, as I have already told that in case of an annual general meeting, all the businesses to be transacted apart from above, that is which I have mentioned, all the four businesses, apart from them, all shall be considered as special business. Okay, now let's move forward and see what would be the next provision. So here it says that section 97 of the act, it deals with the power of tribunal to call annual general meeting. Okay, so section 97 of the Companies Act, it provides for the power of tribunal to call AGM if the company fails to hold AGM. If the company is not able to hold, or if it fails to hold AGM within the time limit given under the section 96, which I have already discussed in my part 1 video, if it fails to hold that AGM within that time limit, then any member can request to NCLT for calling of AGM, and NCLT or the tribunal has the power to call that AGM. Okay, so this is governed by section 97 of the Act. Okay, so as you can see, only 96 is not the section that deals with the annual general meeting. There are many other sections which are interlinked, and here in this video I am discussing about all those sections which are given in different part of the Companies Act 2013, so that it is more easier for everyone to understand the concept. Now comes, what if a company is not able to hold the AGM, or what if the company is not able to comply with the provisions of section 97, that is it is not able to comply with the instructions of the tribunal, with the directions of the tribunal, then what is the penalty? So this is covered under section 99 of the Companies Act 2013. Okay, so what it says is, if a company not holding an AGM as per section 96 or section 97, okay, 96 are general section of annual general meeting, 97 deals with the power of tribunal to hold the AGM. If a company is not able to comply these two sections, if it is not complying with the direction of the tribunal, then the company, and second who comes into the loop is every officer in default, that is every officer of the company who is in default, then they shall be punishable with a fine which may extend, that is the maximum fine would be rupees 1 lakh, and if the default is a continuing one, then the fine may extend up to rupees 5,000 per day till the default continues. So there are penalty, and it's a continuing, if it's a continuing offense, then per day penalty is also levied. So it per day penalty is rupees 5,000 per day till the default continues, and other penalty, which is the basic one, which may extend till rupees 1 lakh. So this is covered under section 99. So apart from section 96, section 129 deals with AGM, with a certain portion of AGM that a financial statement has to be laid down in the AGM by the board of directors. Then section 102, it defines what all are the businesses that are to be transacted in AGM. Okay. Then thirdly, section 97, it gives the power to tribunal to call the AGM if the company is unable to call. And then fourthly, section 99, which deals with the punishment, that if a company is unable to comply with section 96 or comply with section 97 or comply with the direction of the tribunal, if it is unable to do all these things, then a company and every officer in default would be levied with such penalties. So I hope you have understood the concept of annual general meeting, and if any basic point is required for you to understand, then please refer part 1 of my video of annual general meeting. So I hope this concept is clear, and this is all for now. So if you have liked this video, then please like and subscribe. My YouTube channel is PH Webgyan Videos, and do not forget to share and comment on this video. Your comments are valuable, so please do. Thank you, and bye bye, take care.